So shout out to Mickey Truth and shout out to Loyalty and Portrayal because they dropped the bomb on that BS that Trenches News put out, because Trenches News is a paid federal informant. Do your thing, get your coin, bruh. But one thing you not about to do, homie, you not about to sit up here and call my homies don't snitch. So shout out to my brodies out there. They know who I am. They know what it is. We gonna clear up all that BS. Man, let me show you what Trenches News gave y'all, and then I'm gonna show y'all the real and tell y'all what really happened. So shout out to whoever sent me this from Reddit, but basically what they put on here is Trenches News has been pushing false info like the OTF VONNI protective order. This is from a protective order presented by the AUSA. Then here we go right here. Trenches News has been pushing false info like the OTF VONNI protective order. These orders are made in every federal case. It's about discovery. OTF VONNI was just the first defendant that they posted on Pacer from this case. Now let's dig a little deeper. Trenches News also lied when he said they all went to a court hearing and it was vacated 10 days prior. Interesting take. If they can't show the whole thing, what you gotta do is tell them to let it go. We ain't rocking with that. But guess what? For a lawyer, I got that work for you. Enjoy. Now that we got the BS out of the way, let's look at the real stuff. You feel me? United States Attorney Mac E. Jenkins, Assistant United States Attorney's Chief Criminal Division, Ian V. Yaniela, I don't know how to say cuz name, Daniel Weiner, Assistant United States Attorneys. Now, let's just read this. I don't even want to do none of the BS that they was doing. Plaintiff, United States of America, by and through its Counsel of Record, the United States Attorney for the Central District of California and Assistant United States Attorneys Ian V. and Gregory W. and Daniel H. and Defendant Kayvon London Grant, defended by and through his Counsel of Record Peter C. Collectively, the parties, for the reasons set forth below, request that the court enter the proposed protective order. The protective order governing the use and dissemination of one, personal identifying information, PII, of real persons pursuant to Federal Rule of Criminal Procedure, Rule 16, D1, 2, medical and health information, 3, material that may contain information within the scope of the Privacy Act, and 4, information related to protected witnesses who may testify at trial. Introduction and grounds for protective order. 1. The government represents that based on its understanding of discovery in this case, a protective order is necessary in this case. The government incorporates the allegations of the first superseding indictment into its representation that the discovery requires a protective order in this case. Based on the allegations in the first superseding indictment and the government's understanding of discovery in this case, the government alleges that there are significant safety concerns regarding disclosure of names and personal identifying information of victims, witnesses, and defendants themselves in this matter. Discovery in this matter contains the following types of information. Digital devices searched by warrant or consent. In many cases, defendants will receive digital data from devices that did not belong to them. To protect the privacy of the owners of the digital devices, including witnesses, the digital devices or digital data should not be provided to defendants other than for review in the presence of a member of the defense team. Autopsy-related documents, including medical records and graphic photos, including of violent crime victims. The medical information at issue may also be subject to various federal laws protecting the privacy of medical records, including provisions of the Privacy Act, 5 U.S.C. 552A, provisions of the 45 CFR 164, 102-164, 534, and other provisions of 42 U.S.C. 1306 to protect the privacy interests implicated by these photographs and medical records. These should not be provided to defendants other than for review in the presence of a member of the defense team. Audio/video recordings, written summaries of statements, and transcripts of statements made by witnesses to and victims of violent events, including murder. Such documents and recordings often contain the personal identifying information of protected witnesses, and unrestricted release of such items would endanger the safety of those individuals. Audio/video recordings, written summaries of statements, and transcripts of any statements made by defendants to law enforcement. Such documents and recordings will reveal which, if any, defendants have spoken to law enforcement at any time and will endanger those defendants' safety. Surveillance videos of violent events, including murder, and law enforcement reports about such events to protect the legitimate privacy interests of the victims and prevent the use of such items for intimidation purposes. These should not be provided to defendants other than for review in the presence of a member of the defense team. to ensure that information concerning victims, witnesses, and defendants is not disseminated or used by persons who might to intimidate to intimidate or harm victims, witnesses, or defendants, and also to do so in a manner that ensures defendants' rights to prepare an effective defense. The parties respectfully request entry of a protective order for discovery in this case. Federal Rule of Criminal Procedure 16D1 provides that at any time the court may, for good cause, deny, restrict, or defer discovery or inspection or grant other appropriate relief. A protective order is appropriate where there is reason to believe that a witness would be subject to physical or economic harm if his identity is revealed. See Fed R. Crim P. 16 Advisory Committee notes to 1974 amendments. In determining whether a protective order is appropriate, courts consider such factors as the safety of a witness and others and the danger of witness intimidation. See Fed R. Crim P. 16 Advisory Committee's notes to 1966 amendments. The government asserts that the record demonstrates good cause to permit the court to exercise its discretion to restrict discovery and inspection of information concerning victims, witnesses, and defendants in this case, as further described below, and to grant such relief as is necessary to ensure the confidentiality of that information. A protective order is also necessary because the government intends to produce to the defense materials containing third parties, PII. The government believes that disclosure of this information without limitation risks the privacy and security of the information legitimate owners because the government has an ongoing obligation to protect third parties, PII. The government cannot produce to defendants an unredacted set of discovery containing this information without the court entering the protective order. Moreover, PII makes up a significant part of the discovery in this case, and such information itself, in many instances, has evidentiary value. If the government were to attempt to redact all this information in strict compliance with Federal Rule of Criminal Procedure 49.1, the Central District of California's local rules regarding redaction, and the privacy policy of the United States Judicial Conference, the defense would receive a set of discovery that would be highly confusing and difficult to understand, and it would be challenging for defense counsel to adequately evaluate the case, provide advice to defendant, or prepare for trial. An order is also necessary because the government intends to produce to the defense materials that may contain information within the scope of a Privacy Act 5 U.S.C. 552A Privacy Act information to the extent that these materials contain Privacy Act information. An order is necessary to authorize disclosure pursuant to 5 U.S.C. 552A B11. The purpose of the protective order is to allow the government to comply with its discovery obligations while protecting this sensitive information from unauthorized dissemination and provide the defense with sufficient information to adequately represent the defendant. Definitions. The parties agreed to the following definitions. That's where it gets real tricky. Protected witness materials include any information relating to any protected witnesses prior to history of assistance with law enforcement, prior criminal history, statements, or any other information that could be used to identify a protected witness, such as a name, image, address, date of birth, or unique personal identification number, such as a social security number, driver's license number, account number, or telephone number, or discovering containing statements made by defendants to law enforcement that were audio and/or video recorded, summarized in reports or affidavits and/or contained in transcripts. B. PII materials include any information that can be used to identify a person, including the name, address, date of birth, social security number, driver's license number, telephone number, account number, email address, or personal identification number. C. Medical materials include any individually identifiable health information that is connected to a patient's name, address, or any identifying number, such as a social security number. D. Confidential information refers to any document or information containing protected witness materials, PII materials, or medical materials that the government produces to the defense pursuant to this protective order and any copies thereof. E. Defense team includes one defendant's counsel of record, defense counsel, other attorneys at defense counsel's law firm who may be consulted regarding case strategy in this case. 3. Defense investigators who are assisting defense counsel with this case, retained experts or potential experts, paralegals, legal assistants, and other support staff to defense counsel who are providing assistance on this case. The defense team does not include defendants, defendants' family members, or any other associates of defendants. Terms of the protective order. 13. The parties jointly request the court enter the protective order, which will permit the government to produce confidential information in a manner that preserves the privacy and security of third parties. The parties agree that the following conditions in the protective order will serve these interests. A. The government is authorized to provide defense counsel with confidential information marked with the following legend: confidential information. Contents subject to protective order. The government may put that legend on a digital medium, such as DVD or hard drive, or simply label a digital folder on a digital medium to cover the content of that digital folder. The government may also redact any PII contained in the production of confidential information. If defendant objects to a designation that material contains confidential information, the parties shall meet and confer. If the parties cannot reach an agreement regarding defendant's objection, defendant may apply to the court to have the designation removed. Defendant and the defense team agree to use the confidential information solely to prepare for any pretrial motions, plea negotiations, trial and sentencing hearing in this case, as well as any appellate and post-conviction proceedings related to this case. The defense team shall not permit anyone other than the defense team to have possession of confidential information, including defendant, while outside the presence of the defense team, notwithstanding the paragraph above. Defendant may see and review protected witness materials only in the presence of defense counsel or a designed person as defined below. And defense counsel shall ensure that defendant is never left alone with any protected witness materials. At the conclusion of any meeting with defendant at which defendant is permitted to view protected witness materials, defendant must return any protected witness materials to defense counsel, who shall take all such materials with counsel. Defendant may not take any protected witness materials out of the room in which defendant is meeting with defense counsel. At no time, under no circumstance, will any confidential information be left in the possession, custody, or control of defendant, regardless of defendant's custody status. And defense counsel wishes to enable defendant to review protected witness materials in the presence of any person on the defense team other than defense counsel. Defense counsel shall submit a letter to government counsel of record identifying that person, the designated person, and shall submit a copy of this stipulation that has been signed by that designated person. Upon receipt of those materials, if the government in its sole discretion finds the designated person acceptable prior to the designated person reviewing any protected witness materials with defendant, government counsel of record will confirm in writing that defendant is additionally allowed to review protected witness information in the presence of the designated person. I don't know why I keep messing that up. Defendant may review other confidential information, i.e. confidential information that is not protected witness material, only in the presence of a member of that defense team, who shall ensure that defendant is never left alone with such materials. At the conclusion of any meeting with defendant at which defendant is permitted to view such materials, defendant must return such materials to the defense team, and the member of the defense team present shall take all such materials with him or her. Defendant may not take any such materials out of the room in which defendant is meeting with the defense team. Defendant may see and review confidential information as permitted by this protective order, but defendant may not copy, keep, maintain, or otherwise possess any confidential information in this case at any time. Defendant also may not write down or memorialize any data or information contained in the confidential information. The defense team may review confidential information with a witness or potential witness in this case, including defendant. Defense counsel must be present whenever any protected witness materials are being shown to a witness or potential witness. A member of the defense team must be present if other confidential information, i.e. confidential information that is not protected witness material, is being shown to a witness or a potential witness before being shown any portion of confidential information. However, any witness or potential witness must be informed of and agree in writing to be bound by the requirements of the protective order. No member of the defense team shall permit a witness or potential witness to retain confidential information. The defense team shall maintain confidential information safely and securely, and shall exercise reasonable care in ensuring the confidentiality of those materials by 1, not permitting anyone other than members of the defense team, defendant, witnesses, and potential witnesses as restricted above to see confidential information. 2, not divulging to anyone other than members of the defense team, defendant, witnesses, and potential witnesses the contents of confidential information. And 3, not permitting confidential information to be outside the defense team's offices, homes, vehicles, or personal presence. Protected witnesses' materials shall not be left unattended in any vehicle. To the extent that the defense team create notes that contain in whole or in part confidential information, or to the extent that copies are made for authorized use by members of the defense team, such notes, copies, and reproductions become confidential information subject to the protective order and must be handled in accordance with the terms of the protective order. The defense team shall use confidential information only for the litigation of this matter and for no other purpose. Litigation of this matter includes any appeal filed by defendant and any motion filed by defendant pursuant to 28 U.S.C. 2255 in the event that a party needs to file confidential information with the court or divulge the contents of this confidential information in court filings. The filings should be made under seal. If the court rejects the request to file such information under seal, the party seeking to file such information publicly shall provide advance written notice to the other party to afford such party an opportunity to object or otherwise respond to such intention. If the other party does not object to the proposed filing, the party seeking to file such information shall redact any protected witness materials, PII materials, or medical materials, and make all reasonable attempts to limit the divulging of protected witness materials, PII materials, or medical materials. The party agrees that any confidential information inadvertently produced in the course of discovery prior to entry of the protective order shall be subject to the terms of the protective order. If confidential information was inadvertently produced prior to entry of the protective order without being marked confidential information, context subject to protective order, the government shall produce the material with the correct designation and notify defense counsel of the error. The defense team shall take immediate steps to destroy the unmarked material, including any copies. The parties agree that if any confidential information contains both protected witness materials and other category of confidential information, the information shall be handled in accordance with the protected witness materials provisions of the protected order. N. Confidential information shall not be used by the defendant or defense team in any way, in any other matter, absent an order by this court. All materials designated subject to the protective order maintained in the defense's teams shall, let me redo that. All materials designated subject to the protective order maintained in the defense team's files shall remain subject to the protective order unless and until such order is modified by this court within 30 days of the conclusion of appellate and post-conviction proceedings. Defense counsel shall return protected witness materials to the government or certify that such materials have been destroyed within 30 days of the conclusion of appellate and post-conviction proceedings. Defense counsel shall return all other confidential information, certify that such materials have been destroyed, or certify that such materials are being kept pursuant to the California Business and Profession Code and California Rules of Professional Conduct. In the event that there is a substitution of counsel prior to when such documents must be returned, new defense counsel must be informed of and agree in writing to be bound by the requirements of the protective order before the undersigned defense counsel transfers any confidential information to the new defense counsel. New defense counsel's written agreement to be bound by the terms of the protective order must be returned to an assistant U.S. attorney assigned to the case. New defense counsel then will become the defense team's custodian of materials designated subject to the protective order and shall become responsible upon the conclusion of appellate and post-conviction proceedings for returning to the government, certifying the destruction of or retaining pursuant to the California Business and Professional Code and the California Rules of Professional Conduct all other confidential information, i.e. confidential material that is not protected witness material, and 2, returning to the government or certifying the destruction of all protected witness materials. Defense counsel shall agree to advise defendant and all members of the defense team to their obligations under the protective order and ensure their agreement to follow the protective order prior to providing defendant and members of the defense team with access to any materials subject to protective order. Defense counsel has conferred with defendant regarding the stipulation and the proposed order thereon, and defendant agrees to the terms to the proposed order. According to the parties have agreed, request that the court enter a protective order in the form submitted herewith. Is such stipulated, dated December 3rd, 2024. Martin Estrada, United States Attorney. Mac Jenkins, Assistant United States Attorney, Chief Criminal Division. ENV, Gregory W. Daniel H., Assistant United States Attorney, Attorney for Plaintiff, United States of America. Peter C. Swarth, Attorney for Defendant, Kayvon London Grant. Word to the wise. When you don't know what's going on, follow the hood lawyer, because we'll get to the bottom of it. Basically, that wasn't nothing but the government said, you got to agree to not put out this information of people that's actually snitching. How is the government forcing you to not to not let the streets know about snitches making you a snitch? They're saying they got rats, they got snitches, and I ain't gonna hold you. It would not surprise me if Trenches News got on a plane and flew down there and basically lied on Schmirk. You feel what I'm saying? But I'm going to still protect my little bro as much as I can, even though we at odds right now. It is what it is. But I ain't going to let these cats play with your name. And what we not going to do, as far as OTF go, is let this ship sink. Now, the government basically said, hey, whatever you see, you can't speak on, you can't write nothing about, you can't do anything. All you can do is see this was within the front of us. That's all. All that other BS that they running around with, man, come on, Dick, what you on? So nah, man, that paperwork that Trenches News gave y'all and spread out there like false propaganda, that was the FBI putting that out there so that they can get people within the circle to start telling. Do not be surprised that if anybody involved in this is not telling, because one of the first things that happened, and my eyes got bigger than normal, was that, hey, bruh, they're saying they're already threatening witnesses. And then they try to say that Jam was telling. Word? Let me ask y'all this simple question. Why would it get out that fast? All these conspiracy theories are just conspiracy theories. They're not real. We won't know anything until people pop up in court, put their hand on that Bible and swear to God. And from that paperwork and what they read, the state might win, but they might lose on an appeal. And if they lose on an appeal, then there you go. They don't want to lose that appeal because they're probably thinking to themselves, like Fonnie Willis was, we going to get this witness in here that said this and said that, not knowing that that person was probably trying to save their own skin, made up some stuff, knew a little bit of something, threw it together and seen what the hell stuck. Imagine this scenario, if you will. One of them cats was bragging. Man, bro, look. Man, look. We so cold, we went out there and tried to smoke Quando Rondo, but got a little pop up out the way, bruh. But hey, we so cold with it, man, that we made it look like a business hit. Cause we had asked Durk to use the plane. Durk like, yeah, but don't put it in my name. You better use that company card. That's my tax write-off stuff right there. And then you already know shit. Durk don't know, but man, yeah, you know, some of them lyrics, man, the police gonna look at it like, yeah, he told us to do it. Or some of them songs, man, Durk called it before we even did it. I'm telling you, Drew Feeling is the GOAT. I believe in Drew, and so should you. But don't believe anything, nothing, with that many grammatical errors and all that stuff. When they got errors like that, when they see all them errors, bruh, come on, man. We don't believe you. All that paperwork they have, all that paperwork they be making up. Yeah, all that paperwork that they make up with all them grammatical errors. Man, get out of here, bruh. Come on now. So nah, Trenches News lied to y'all. I hate I even had to bring Buddy's name up because I already know what they're going to do. Mr. on the news, boom, boom, boom. Yeah, that's cool, but ain't nobody talked in that case. You can look that one up online. And ain't nothing ever been associated with Seti National ratting, for sure. It's all y'all made up stuff because y'all channels ain't popping. But shout out to you, bro. Ain't no static with you or anything like that. I'm just not going to let you lie on the homies. Because at the end of the day, even though I ain't really rocking with too many cats up over there, I'm still not going to let nobody play with my guys' names. That's out. So we kill all that noise right here. Seti Nash, the hood lawyer. Stay. Figure out how you can win yourself an Xbox or a PlayStation because we just went up 1,000 subs in the last 2 days. So it's seeming like in a couple months, we're going to hit that 300K. But find out how you can win today.